Good day everyone, I am Ben Duchesne from BSc 3-5 and my topic is all about domestic arbitration. First is objective. At the end of the discussion, the student should learn and know about the meaning of domestic arbitration, to determine what is the purpose of domestic arbitration, and to be able to identify how domestic arbitration works. So, first is, what is domestic arbitration? Domestic arbitration is a form of an alternative dispute resolution or ADR that involves resolving disputes between parties within the same country. In the contrast to international arbitration, where the parties involved from different countries, and domestic arbitration deals with disputes arising within the border of a single nation. Like international arbitration, domestic arbitration provides an alternative to traditional court litigation. To added, in general, arbitration is domestic if conducted in the Philippines. Specifically, arbitration is domestic if the component of parties, place of the business, place of the arbitration, and place of performance of substantial part of the obligation, and place where the subject matter of the dispute is mostly connected to all located in the Republic. The Alternative Dispute Resolution Act of 2004 devoted only two sections, namely Section 32, which distinguished domestic arbitration from international arbitration and declared that the arbitration law, or RA number 876, remains to apply to domestic arbitration, and Section 32, which adopted certain provision of the model law and the Alternative Dispute Resolution on International Commercial Arbitration to domestic arbitration. Disputes covered by rules on domestic arbitration. The rules on domestic arbitration cover both commercial and non-commercial disputes, provided they are susceptible of arbitration and do not fall within the exclusive original arbitral jurisdiction of quasi-judicial agency. Unlike the provision of the ADR Act on International Commercial Arbitration and the rules corresponding to it, which cover only disputes arising from relationship of a commercial nature. Unlike the provision of the Alternative Dispute Resolution Act on International Commercial Arbitration and the rules of corresponding thereto, which covers only dispute arising from relationship of a commercial nature, and the provision and the regulation on domestic arbitration cover both commercial or commercial means of settling disputes by referring them to an arbitrator selected by the parties, or a decision based on the evidence and arguments presented on the arbitration tribunal. The non-commercial disputes are provided they are susceptible to arbitration and do not fall within the exclusive original arbitration jurisdiction of quasi-judicial agency. Next topic is due process in domestic arbitration. The parties to a domestic arbitration, like in the case of international commercial arbitration, are entitled to be treated equally with due process. On due process, in the case of involving a domestic arbitral proceeding, the Supreme Court will hold the well-settled rule in the administrative agency exercising quasi-judicial power shall not be fettered by the rigid technicalities of procedure. They are all times required to adhere to the basic concept of fair play. Like in the case of international commercial arbitration, are entitled to be treated equally and with due process in case of domestic arbitration proceeding. The Supreme Court will hold that the well-settled rule that administrative agency exercising quasi-judicial power. The main focus is to respect for the rule of equal treatment of all people concerned. Next is place of arbitration. The parties are free to agree on the place of arbitration. Failing such agreement, the place of arbitration shall be in the Metro Manila unless the arbitral tribunal, having regard the circumstances of the case, including the convenience of the parties, shall decide on the different place of arbitration. So, different place taking account the consequences or circumstances of the case and the convenience of the parties. Next topic is all about language of the arbitration. The parties are free to agree on the language or languages to be used in the arbitral proceeding. Filing such agreement, the language to be used shall be English in international arbitration and English or Filipino for the domestic arbitration, unless the arbitral tribunal determines a different or another language or languages to be used in the proceeding. This agreement or determination, unless otherwise specified therein, shall apply to any written statement by a party, any hearing, and any award, decision, or other communication by the arbitral tribunal. To added, the rule in the determination of the language that will be used in the arbitration proceeding is the same for domestic and international commercial arbitration, including the prerogative of the arbitral tribunal to require a translation of a documentary evidence if not in the official language, except that Filipino is added to English as default language in domestic arbitration. Next is the arbitration proceeding records evidence, arbitral award, and other confidential information are privileged and shall not be published except with the consent of the parties or for limited purpose of disclosing to the court relevant documents where resort to the court is allowed, and the court may be issue protective orders to prevent or prohibit the disclosure of documents or information containing secret process developments, research, and other informations. Written communication means the pleading motion, manifestation, notice, order, award, and any other document or paper submitted or filed with the arbitral tribunal or delivered to a party. Rule in written communication in the absence such an agreement, written communication among the parties and the arbitrator shall be delivered personally. Next is the waiver of the objection. A party may be stopped from questioning non-compliance or is deemed to waive his objection there is if he fails to object without delay or within the time prescribed, therefore 30 days if no period of prescribed. The concept of waiver can be defined with respect of party that proceed with the arbitration without raising an objection even knowing that the requirement under the agreement has been complied. They provided that he or she knows absent non-compliance, so act of omission, particularly to waive or stop it. Stop it means preventing something to question. Next topic is all about presentation. The same rule on presentation in international commercial arbitration is obtained in domestic arbitration. A party may present himself or be presented or assisted by any person by his choice, provided that such presentation, unless admitted to the practice of law in the Republic, shall not be authorized to appear as counsel in any Republic court or quasi-judicial body. In terms of formal requirements of arbitration agreement, according to the arbitration law, an arbitration agreed must be in writing and duly subscribed either by the party to be held accountable or by their authorized representative. A domestic arbitration are free to agree on the procedure for the appointment of the arbitrator except in the order to prevent undue advantage. An agreement or clause giving party to the power to choose more arbitrators than the other is void. First is appointing by the parties. In arbitration, with 3 arbitrators, each party shall appoint, and 2 arbitrators appointed shall appoint the third arbitrator within 30 days from receipt of request, failing of which the appointment shall be made by the appointing authority. Next is default appointment by appointing authority. A default appointment time to make the appointment but not more than 30 days. As for an appointment, within 7 days from the receipt of request, the adverse party may file his objection to the request or ask for an extension not exceeding 30 days to appointment an arbitrators. Breakdown of its key aspect of domestic arbitration. Parties involved. Typically, 2 or more parties involved in a contractual or legal dispute agreed to have their case heard and decided by an arbitrator instead of going through the traditional court system. To added in parties involved, which is must be 2 or more parties have a contract to agree that their case must be heard and decided by an arbitrator and instead of going to traditional court system. Next is arbitrators. The parties or an arbitral institution choose the arbitrators based on their expertise and neutrality in the subject matter of dispute. Arbitrators can be lawyers, judges, academics, or other professionals with relevant experience. Hearing process. The arbitration hearing is usually less formal than a court proceeding, and the rules of evidence may be more flexible. Both parties have the opportunity to present their arguments, submit evidence, and cross-examine witnesses. So in a hearing process, the parties have a free will to present their evidence or arguments to the other parties. Benefits of domestic arbitration: speed and efficiency. Domestic arbitration is often faster and less expensive than litigation in the public court system. Next is flexibility. The parties have more control over the arbitration process, including the choice of arbitration and the rules of procedure and the law that will be applied to the disputes. Next one is the privacy and confidentiality. Arbitration proceedings are usually confidential, which be all important for business or an individual who wants to keep their disputes in private. Next one is expertise. Arbitrators can be chosen for their specific expertise in the subject matter of the disputes, which can lead to a more informed and just decision. I hope you enjoy watching this video and I hope you had learned about the domestic arbitration and thank you for watching. Once again, I'm Ben Shane from BSC 3-5.